And we're live.
Sorry, I was muted. You think after almost a year and a half of being in a Zoom pandemic that I figured this out already. But hey, everybody, I'm Paul Lopez. I'm the Denver Clerk and Recorder. We are now at 6 p.m. and folks are joining us live on Facebook. This is another town hall that we have. It's a town hall that's focused on foreclosures, focused on financial health, and making sure that folks have the opportunities and the tools necessary to be able to navigate some, sometimes some very intimidating procedures. Foreclosure process is always tough. Things that have to deal with your pocketbook and are hard as well too, and they are often very complex. In terms of having a sound financial health. Our office, my office, the office of the clerk and recorder, because I'm also the public trustee, we also are responsible for overseeing a fair and public foreclosure process. Know that we don't offer any legal advice or take any sides in the matter. We are just making sure as a public third party that the process is fair and transparent. This meeting is being recorded and will be provided online and on our website, denverclerkandrecorder.org, with links. So those of you who may not be able to attend this evening will be able to attend in the future, along with the other town halls that we've had. We have a pretty awesome town hall tonight. And also for captions, I want to make sure that people know on Facebook Live that you're able to activate captions and things like that. And if you have any other questions, we'll have an opportunity to ask questions and from the chat and direct those questions to panelists or to myself. First things first. That's not the first thing. I want to say something very important, and that is that it's okay to ask questions. The second thing is that you're not alone. There's a lot of folks, especially after the pandemic, that have had an impact to their pocketbook, to their financial health, and sometimes even to their homes. Now that the foreclosure crisis, or not crisis, but now that the foreclosure moratorium has ended and that moratorium has been lifted, we're going to start seeing an uptick in foreclosures. Some of those things are actually pretty complex, but what I want to say is that if you get that notice, it's not game over. There are a lot of different steps and a lot of different things in this complex process that you are able to do. And for that information, just kind of tune in on some of these webinars that we've had and some of these town halls. And also you can hit us up at denverclerkandrecorder.org. And you could also hit us up at 311 from your phone if you're in Denver. Without further ado, I am going to introduce our speakers and also inform you of some other town halls that are going to be coming down the way as well too. So our first speaker is Mr. Jeffrey Salant, who's an HOA information officer with the Division of Real Estate with the Department of Regulatory Agencies for the state of Colorado. I want to introduce and welcome Mr. Salant. If I'm pronouncing your name right, I should have asked you right before, but he's going to do a presentation on HOA issues as they relate to foreclosure. Go for it.
Thank you. Thank you very much, Clerk Lopez. I appreciate that. Good evening, everyone. I have a lot of information to share tonight, so I'm going to hop right in. If we can go to the next slide, please. Please note that the information provided during this presentation is for educational purposes only, and it is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Next slide, please. I want to take a moment and talk to you about my office, the HOA Information and Resource Center. The HOA Center is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA Center provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act. It gathers and analyzes and reports information through complaints and HOA registrations. We write an annual report, which is made publicly available each year. We create resource materials, provide education, and present HOA forums similar to this one. We also maintain a website with information for the public. That's dre.colorado.gov. Go ahead and navigate to the HOA Center once you're there. And we also register HOAs. Next slide, please. As for what my office does not do, the HOA office is not a regulatory program. We are not able to mediate or arbitrate. We cannot provide legal advice. We do not act as an advocate. We cannot assess fines or penalties, and we do not enforce an HOA's failure to register. Next slide, please. So in Colorado, HOAs or common interest communities are governed by the Colorado Common Interest Ownership Act, colloquially referred to by its initials, CCIOA or Kiowa. This statute defines the rights of a unit owner as well as those bestowed upon the association. It defines the responsibility of an association as directed by its executive board. Kiowa also provides for the enforcement of those rights and responsibilities through civil litigation. So what that means is, unfortunately, the state has no authority to intervene in any association member's conflict with their association, nor does it have any jurisdiction to enforce the rights and responsibilities defined in Kiowa. Succinctly speaking, there is no regulatory oversight of HOAs in the state of Colorado, and any dispute between homeowners or homeowners and an HOA is considered a civil matter. Next slide, please. So while membership in a very few number of HOAs is voluntary, the vast majority of HOAs in Colorado are mandatory. This means that membership is automatic upon purchasing your home, townhouse, condominium, when it's located in an HOA. The relationship between an association and its members is contractual in nature. So what that means is that the terms of your contract with your HOA are your governing documents collectively, your declaration, bylaws, rules, regulations, as supplemented by that state statute, Kiowa. When you purchase property located in an HOA, the recording of your deed is similar to your signature on a contract. Next slide, please. When you purchase a home in an HOA, again, you agree to restrictions on the use of your property through covenants and rules. Decisions made by persons who you may not know can affect the use and enjoyment of your property, your lifestyle, your freedom, and specifically your finances. There may be decisions made by a few persons on an executive board or committee that do not reflect the view of the majority of homeowners in that community. If you do not agree with the decisions made by the board, your first remedy is to use the democratic process, which means seek election of other members of the HOA that you're more sympathetic to your concerns, which may be a difficult process in an HOA where not many members are active. Seeking election yourself is also a great way to try and obtain some oversight within your community. And you may also wish to attend board meetings and appropriately voice your concerns on a given issue. However, with respect to items that the board has complete authority over, such as the hiring of a community association manager or the manner in which maintenance is performed, attending board meetings and voicing your concern on any given issue may be the extent to which you are able to influence the outcome. However, in circumstances such as covenant violations or architectural review committee findings, you may try and engage your board in something called alternative dispute resolution, such as mediation or arbitration. However, that process is a voluntary process, and if your board refuses to participate or you are unsuccessful, your last resort will be to contact an attorney and file suit in court. Next slide, please. So community association management involves all aspects of operating a common interest community. In a self-managed community, the association will utilize volunteers, specifically the board of directors, to do all of the work. Everything from the management of the association's daily routine tasks to the enforcement of rules is done by volunteers from within the association. The roles and responsibilities of the board can generally be divided into two categories, delegable duties and non-delegable duties. Delegable duties may be delegated to volunteers, while the board must execute their non-delegable duties themselves. Next slide, please. So what is professional community association management? Well, generally speaking, it involves performing services as the agent of a board for an association. As the agent, the community association manager performs services in connection with some or all of those delegable duties of the board. And a few examples of these delegable duties might include the collection of dues, the enforcement of covenants, enforcement of rules and regulations, sending out notices, record retention and production, things like bookkeeping, drafting a proposed budget, filing insurance claims, as well as assisting the board in coordinating and conducting meetings. And these are just some of the board's delegable duties. Some examples of non-delegable duties include voting on community issues, voting on appeals of community violations, adopting a budget, and waiving dues, fees, or fines levied by the association. Next slide, please. Community Association Manager, or CAM, licensing and regulation previously existed in the form of the CAM program housed here in the Division of Real Estate from January 1st of 2015 to July 1st of 2019. In May of 2019, the Colorado General Assembly passed House Bill 19-1212, which would have continued the CAM licensing program. The bill was vetoed on May 31st of 2019 by Governor Polis, and the CAM program did expire on June 30th of 2019. There were some additions to his veto in the form of an executive order, which directed a stakeholder process. And if you'd like to learn more about that, you can find a plethora of information on our website. Most importantly, currently there is no regulatory oversight of either HOAs or community association managers. Next slide, please. Although neither the HOA Information Resource Center nor the Division of Real Estate have any investigative or enforcement capabilities to address HOA complaints, we do accept complaints and record the issues and matters of concerns into a statistical database, which is later compiled into our annual report. Of note, in 2020, 21% of all complaints received by the HOA Center were filed against a community association manager, with an additional 16% listing both the CAM and the board as respondents. It's important as a homeowner to understand the distinction between your board and the HOA, for the HOA and the community association manager. Whereas the management company is responsible for the day-to-day maintenance and upkeep of the HOA, the board is ultimately responsible for all of the decisions of the HOA. So it's very important before purchasing in an HOA, you may want to learn the name of the management company if there is one, and research its reputation, since they will become an absolute part of your life in an HOA. Next slide, please. When budgeting for a home purchase as a potential buyer in an HOA, it is essential to know what the dues are and to understand whether any additional special assessments are projected. According to Colorado law, during the negotiation of the purchase of residential real estate, the seller is required to disclose whether the property is located in an HOA. Prior to making a decision, new home buyers should obtain and review all of the documents required to be provided in Section 7 of the Colorado Contract to Buy and Sell Residential Real Estate in order to determine the financial health of the HOA. The seller should provide you with the HOA documents, including, but not limited to, a copy of the covenants, the bylaws, minutes of the most recent annual owners meeting, minutes of any board meetings, and the most recent financial statements, if available, during the 6-month period immediately preceding the date of the contract. While real estate brokers should absolutely assist in facilitating the provision of these documents, they should not try and explain them. Any questions about governing documents or financial records of the association should be addressed with a qualified community association attorney or a Colorado CPA. Next slide, please. So with regard to additional financial responsibilities, generally there are two types of assessments. regular, known as dues, and special. Regular assessments are typically paid on a monthly, quarterly, or annual basis, while special assessments are usually less frequent and they're made on an as-needed basis. Regular assessments go towards the overall operational maintenance costs, while special assessments are usually made for a specific purpose, such as repair, maintenance, replacement, or new construction. Potential purchasers of property in an HOA should work with their broker to ensure that they're informed of any upcoming special assessments. The title company may have this information available, and buyers should also review previous meeting minutes for an indication of a special assessment. Next slide, please. So each unit owner is liable for the payment of the assessments that are levied against their unit during their period of ownership. Associations are allowed to allocate assessments using different formulas. So some people might be paying different than their neighbors, and that could depend on a lot of different formulas. However, no unit owner is exempt from the payment of assessments because they haven't used any of the common elements or any of the recreational areas, or even if they've abandoned their unit. It is still your responsibility so long as you're an owner. So therefore, it is absolutely essential that each unit owner determine what their financial obligations will be as an owner in an HOA prior to closing on that property. Next slide, please. One of the several responsible governance policies that HOAs are required to have is a policy on the collection of unpaid assessments. This policy should include items such as the due date of the assessment, as well as the date that it is considered past due, late fees and any interest that may be charged, and any payment plan options, keeping in mind that Kiowa requires that an association, upon request, make good faith efforts to coordinate a payment plan with a delinquent owner who has not already entered into a payment plan with the association. That's a pretty big catch. If you've already requested a payment plan in the past, the HOA is not obligated to give you another one. A collection of unpaid assessments policy should also include notice requirements and a description of the action required to cure a delinquency. But keep in mind that Kiowa also requires an association provide at least 30 days to cure any deficiency, or delinquency rather, excuse me. Next slide, please. So liens, one of the most powerful tools available to HOAs in Colorado is the statutory lien. A statutory lien exists on any unit for any assessment levied against that unit or fines imposed against the unit owner. Interestingly, unless an association's declaration provides otherwise, Kiowa describes the term fines imposed to include fees, charges, late charges, attorney's fees, fines, and interest charged against the unit. The association has what's called a super lien, meaning it has priority over all other liens except those liens which were recorded before the association's declaration, any mechanics or material men's liens, and of course, real estate taxes and other governmental assessments or charges. Next slide, please. Generally, liens have to be recorded in order to be perfected. However, in Colorado, the recording of an association's declaration constitutes record notice and perfection of the lien. The association does not need to take any further recordation of any claim of lien for assessments for the lien to be valid. Interestingly, an association has 6 years from the time the full amount of assessments becomes due to institute enforcement actions. Any lien for unpaid assessments is extinguished unless those proceedings to enforce the lien are instituted within that 6-year time frame. Next slide, please. Upon request, an association is required to provide a written statement of the amount of assessments owed by and currently levied against a unit owner. This statement must be provided within 14 days, and if the association fails to provide the statement, the association may not assert a lien for the unpaid assessments due as of the date of the statement. So anything after that they can, but anything before that they are unable to. The statement is binding on the association, the executive board, and every unit owner. Next slide, please. An association's lien may be foreclosed upon in a similar manner as a mortgage on real estate, but only if a unit owner's delinquency exceeds 6 months and the board has formally voted to authorize the filing of legal action. The board is not able to delegate that duty to anyone else. And importantly, any legal action that is filed without some sort of evidence of that recorded vote authorizing the enforcement action must be dismissed. No attorney's fees, court costs, or other charges incurred by the association in connection with an action that is dismissed for this reason may be assessed against the unit owner. So that's a really high bar there, and the association must be certain to follow those formalities. Next slide, please. Talking about costs of a foreclosure, if an association obtains a judgment in their favor under this section 38-33.3-316, they are entitled to recover their costs and reasonable attorney's fees. Attorney's fees for judicial foreclosures are typically billed on an hourly basis, and the typical average is between $3,000 and $4,000, with costs averaging an additional $600 to $800. That would be for filing costs, serving the defendants, title work, as well as any applicable sheriff's charges. Whereas the attorney's fees for a contested foreclosure may run in excess of $7,000 or more, depending on how vigorously the defendant defends the case. Next slide, please. With regard to some best practices for associations, when enforcing any association policy, including the collection policy, it's important that the board maintain consistency in their application. That being said, at the same time, it's also important to recognize special circumstances, especially now during these times. Balancing the needs of the association with reasonable compassion for your neighbors is a significant challenge for boards. Be sure to communicate as effectively as possible. And although it may become necessary at times to use the association's counsel to communicate with delinquent members, it can also be very costly, and it should only be used when absolutely necessary. Keep in mind that effectively communicating includes effectively listening. I encourage board members to invite your members to provide feedback on association processes. While the board of directors gets the final say in most circumstances, understanding how your membership feels about the association processes and procedures may help you be able to better enforce them more effectively. People are always more likely to follow rules when they agree with them. So keep that in mind. Next slide, please. And as a homeowner in an HOA, some best practices, quite obviously, keeping current on your HOA assessments is the best way to prevent an association from foreclosing on your home. Many times homeowners will reach out and they'll tell me that since their HOA isn't doing maintenance or they're not doing a very good job, that they're going to withhold their dues and they're not going to pay the HOA. It's important to understand that this only hurts the homeowner. You are not sticking it to your association by not paying them. The association can and will go after delinquent homeowners, and they can and they will charge legal fees and other costs for doing so. As with most circumstances in an association, communication is paramount. Make sure that the management company or the board has your accurate contact information on file. We frequently hear from homeowners who don't realize that they're in arrears because of a missed payment or a mistaken payment until long after the fact because their contact information was not current with their HOA. That's a simple way to stay on top of things. You should also consider to communicate with your board in writing once a dispute does arise. This may help preserve evidence of certain correspondence if litigation later becomes necessary. Finally, strongly consider participating more in the governance of your association. Attend every board meeting, every membership meeting, talk to your neighbors, talk to your board members, and lastly, please consider running for the board yourself. Next slide, please. I appreciate all of your attention. I know that was a lot of information. We obviously will have a questions time at the end of this presentation, but if you have any longer questions or specific questions you'd like to speak with me one-on-one, here's all of my contact information. Please do reach out. I look forward to hearing from you.
Thank you, Jeffrey, Mr. Salant, that was awesome. And I think, this is one of those things, it's one of those finite parts of the process that a lot of people just may not understand. And I'm glad that this presentation, like I said, is available and will continue to be available after we've done this town hall. It's being recorded and it'll be available on our website, denverclerkandrecorder.org, and you'll have opportunity to ask questions. And please, if you have a question right now, put it in the chat and then we'll put it in the queue. So thank you so much, Mr. Salant. And I'm pronouncing it right?
You sure are. Thank you for asking.
Oh, okay, good. Our next speaker is Mr. Jose Vasquez, the supervising attorney with the Consumer Law Unit with Colorado Legal Services. Mr. Vasquez has a pretty awesome bio, so I'm gonna kind of whip through it a little bit. You're the supervising attorney for the Consumer Law Unit, Denver office of Colorado Legal Services. He specializes in consumer bankruptcy and the foreclosure / homeownership defense. He also oversees the foreclosure project, which is funded by the payment of mortgage settlement funds, which employs attorneys within CLS, Colorado Legal Services, to provide foreclosure assistances to clients on a statewide basis. He's been a practicing attorney on consumer bankruptcy representation. He's been a speaker on various housing and consumer rights topics. He received his BA from Miami University in 1988 and his JD from Case Western Reserve University in 1991. So he's been up to a lot of cool stuff. He's a member of the Colorado Supreme Court Civil Rules Committee. I think he knows what he's talking about.
You don't have to go any further.
Yeah. So this man probably has multiple. So anyway, Mr. Vasquez, welcome. And again, folks, for us, we can't provide legal advice or anything like that. We don't take sides in these foreclosures, in these cases, but we do want to make sure that everybody is connected to resources. And I really appreciate you joining us, Mr. Vasquez. The screen is yours.
Thank you, Clerk Lopez. I appreciate the introduction and just appreciate the opportunity to be here to talk about this particular area. So just really briefly, Colorado Legal Services. We have a website, www.coloradolegalservices.org. And if you meet our criteria for applying, you can apply there. I'm going to go ahead and share my screen, and let's see here. Hopefully I can do this. Okay, there you go. You should see on your screen Homeowners Association collection actions. And first of all, I just want to really commend Jeffrey Salant for his presentation. It was top notch. It was a lot of information, but all of that information is extremely important because this information really could make a significant difference to homeowners. And there's a lot of documentation involved in this, which oftentimes if we look at documentation and there's too much, we tend to gloss over it. So with that, we'll go ahead and start. Let me see here. Okay, a lot of this is pretty basic, and I'm going to try to go through my presentation as quickly as I can. A lot of points Mr. Salant has made already. These are some statistics that I found regarding HOAs and regarding homeowners associations. They're becoming a significant part of home ownership in Colorado. So I'm not going to really talk too much about these statistics, but just important to know that if there's new housing, it's probably likely that there are covenants that control the design, the manner in which these properties are built. And so this is becoming more and more important. So when we talk about homeownership preservation, foreclosure, we certainly need to be aware that the association has significant authority, and these covenants have very significant consequences if the homeowner does not comply. So just Mr. Salant already covered the basics of homeowners association, but I do want to point out a few things, and that's that homeowners associations basically have a fiduciary duty to the membership of the association. So they have the obligation to enforce the covenants and rules of the neighborhood as applicable. And so that's important because the association, they have to follow the rules that govern the association, the bylaws, the declaration, the policies. And as Mr. Salant mentioned, that's all final decisions are made by the board. I have a slide here on community association managers. I'm not going to spend much time on that. I have a slide here that talks about just the governance of the HOA. And again, I think even if this information is repetitive, it's important for individuals to know this. We see probably a significant influx of people coming to Colorado. And so you may have come from a state where homeowners associations are not as prevalent. I'm from the Midwest, and the state that I spent most of my life did not really have a lot of homes subject to covenants. So it's important to understand these things. I'm going to not spend a whole lot of time on the slides here. I've already talked about the fiduciary obligations. The HOAs by law are required to comply with the provisions of Kiowa. And so when we look at, if we look at the homeowner and they are, they have issues with the association, just like the homeowner has obligations to pay assessments and have their property comply with the relevant rules. The HOAs also have a duty to comply with the governing documents. This is just discusses the disclosure requirements of the HOA, the obligations for the homeowner. Mr. Salant already talked about this, the assessments, the requirement to pay an assessment, which is typically a monthly fee. In some cases, it can be quarterly, and I've had clients that have had an annual fee, but it's not too common. And those are some figures that I found in terms of the amounts of an HOA. The obligation of the homeowner also includes paying special assessments. So in counseling clients who come to me with HOA, I'll just refer to these homeowner associations as HOAs. One of the issues that comes up is a special assessment, because oftentimes a special assessment is not just the periodic assessment fee that is paid, but it's typically funding a major expense or repair to the association as a whole. So that's one of the things that can certainly cause some big issues. If the homeowner gets a bill, it's a $6,000 special assessment. That's a lot of money for anyone. So that's certainly something that could result in late fees and penalties if it's not paid. One of the things I included in here, just from my talking to homeowners and people representing associations, is if you own a home and it's subject to covenants, there is a special homeowners insurance. I believe it's called an HO6 policy that could provide coverage for special assessments, maybe all or part or some of that. So that's just a piece of information I want to get out there. The other part of the legal obligations of a homeowner is to comply with covenants restricting use and construction. And so that's the other part of the association. The association is, it is important for them to maintain, in many cases, consistency and uniformity throughout the neighborhood. So certainly somebody who chooses to ignore those rules certainly faces some consequences. Here's the thing that happen if a homeowner fails to comply with the HOA rules, and we'll go through these a little bit more carefully. So if a homeowner fails to comply, in this case, we'll discuss the failure to pay assessments. Homeowners will, after demands for payment, they'll receive, they could be sued. There could be a lawsuit to get a personal judgment against the homeowner, because by law, the homeowner is personally liable for the assessments. So typically the lawsuit will be filed in county court. The jurisdictional limit of the county court is up to $25,000. So in most cases, a collection suit will be done in the county court. And if a person receives a summons and complaint, then they have, they have a certain period of time in which to respond and defend the lawsuit. Mr. Salon talked about the recording the assessment lien on the property. So by statute, that is an automatic, it's a statutory lien. But in many cases, the associations do record an actual assessment lien. So when we pull up title documents for homeowners, we'll find the assessment lien. Mr. Salon already talked about the super lien status. Now, the significance of the lien is that this gives the Homeowner Association the ability to file a foreclosure action. Now, the foreclosure action, it cannot be filed in county court. It has to be filed in district court. Okay, so the purpose of the foreclosure is to force a sale of the house, and by forcing a sale of the property, then the assessment lien and all other charges and costs which are alleged to be owed will be paid. The foreclosure on an assessment lien is something which is not uncommon. I can tell you from the many individuals that come to our office for assistance, in many cases, we've seen foreclosure actions filed for non-payment of association of assessments. This is a slide that just talks about the assessment lien. The other remedy, there's a remedy that the association can pursue, and that's an action for injunctive relief. So the association may, in some cases, not just file an action to recover the unpaid assessments, but they can also get a court order, basically an injunction, which basically would prevent the homeowner, would restrain the homeowner from constructing or implementing, changes to their property, which may be in violation of the covenants. So that's another remedy that the association has. This is really very in depth, but the association can also put the property in a receivership. And basically receivership is where basically the party that has the ability to ask for receivership can ask that somebody basically take over the property and collect rents, make sure that the property is in good condition and it's maintained. And that's a pretty serious legal remedy as well. It's not really too common. Generally, we see the summons and complaint for collection or the judicial foreclosure. So if you're a homeowner and you receive notice of a delinquency, it's important to get those documents, to get a copy of the declaration, the collection policy, and any other governing documents, any letters, notices. This is really important because if you talk to an attorney, those are the first, that's the first thing the attorney is going to want to see is the documents at issue. The homeowner needs to request a ledger to see what the charges are. And that's one of the things that I always ask for on behalf of the homeowners is how much is owed, because that should provide a breakdown. If the person has the ability to pay the amounts, you know, they can bring it current if they owe it. Now, one of the requirements of Kiowa is that the association's collection policy has to provide those 3 things under paragraph 4: good faith effort to reach a agreement on a payment plan. The plan consists of equal installments and the plan be over the course of at least 6 months. So at a minimum, if there are past due assessments, the homeowner has to be offered at least a 6-month repayment plan. If the client or the homeowner, if you don't believe that you owe the association amount, it's important to get the ledger to see how the amount was determined. The homeowner can pay that amount under protest and file a legal action to recover the funds. So I will echo what was said earlier regarding individuals who make the decision that they're so frustrated with the association that they don't make payments for the assessments. That's extremely, extremely risky. And what I counsel my clients is to pay them if they can, to pay it under protest. And, you know, basically it puts them in a situation where they're not on the defensive, but rather they have the ability to, you know, to pursue an action more in the driver's seat. If there's a dispute, then the remedy really is to file a lawsuit called an action for a declaratory judgment. And that is basically when you as the homeowner file an action with the court, and you want the court to settle a dispute between you and the association. And the court has the authority then to review the governing documents, to review all the evidence, and decide who is correct, who is right and who is not right. Then the other option is to refuse to pay and defend any lawsuit to collect. Again, that's risky for refusing to pay. Here's some possible defenses to an HOA collection action. So first of all, I just want to emphasize that it's important to talk to an attorney as far as assessing your case involving a homeowners association, because what I don't want people to think is that the association is coming after them. They're suing the homeowner, and there's really nothing they can do about that. But these defenses, they go to the legal requirements, the legal duties of the association. A failure to comply with adoption of policies and following those policies is a defense. Failure to provide required notice, failure to engage in good faith. Now, one of the one of the points there is failure to afford the homeowner a chance to be heard by an impartial decision maker for covenant violations. So Colorado law actually says that if there is an alleged covenant violation, so we're talking about a situation where the association is alleging that the homeowner has violated the covenant, and oftentimes the association will impose fines. Okay, they'll impose fines for failure to comply with those violations. Kiowa requires that the associations provide an impartial decision maker to provide the homeowner a hearing before they can pursue legal action. So if there is a question about the fence or the color of the home, the homeowner has the ability to ask for a hearing, an informal hearing first. It has to be an impartial decision maker. And there's other defenses here. I mentioned bad faith, other traditional offenses, traditional legal defenses, because these are defenses in contract. I mean, this is a contract action, so that is certainly worth bringing up. What about attorney's fees? I look at the slide, and certainly it's quite clear that the association does have the right to collect the costs of collection. Okay, but the declarations, some declarations are silent on it, but many of them say this attorney's fees must be reasonable. I believe Kiowa mentions that as well. But it's important to note that the attorney's fees have to be earned, and the costs have to be proven. So what I would caution people, in terms of defending an association action, is making sure that the costs and fees have actually been earned, that they're reasonable. It's not uncommon to find in the ledger and in other documents, there are a significant number of fees, and they're very difficult to understand what those fees are for. It's very difficult to understand how those fees were authorized. So always important to take a look at that, because it's certainly not any attorney's fees the association incurs is recoverable. In a court action, attorney's fees are awarded to the prevailing party. So if you successfully defend against the Homeowners Association action, you as a prevailing party could recover your attorney's fees. So that's an important statute to keep in mind in a situation where you feel pretty confident that the association isn't doing what they're supposed to do. These are some duties the association has under Kiowa. Here's a slide that describes a little better what I was talking about before attempting to fine a homeowner for covenant violations. These are the requirements before they can even impose a fine, let alone file an action. And these are some other requirements that before attempting to collect for missed assessments, these are the requirements that they have to comply. So you can see that there's a lot in the statute, there's a lot in the declaration, and most individuals, you're not going to be able to synthesize all of this information. And that's why having these documents reviewed by an attorney, because we love to read long, tedious documents. That's what we are trained to do. So, having the assistance of an attorney here really makes a huge difference, because oftentimes what I see is that there isn't compliance with all of these requirements. And so, that's important to explore and understand Okay, and I had some information here about the HOA Information Resource Center, but let me just say that, you know, as Mr. Salant mentioned earlier, that the associations do not have, there's no regulatory body, there's no agency that has the ability to hold associations accountable. And certainly that is, you know, that can be problematic for a homeowner, because the homeowner oftentimes will have to rely on the courts. And so that's the opportunity, really, in which to try to settle these cases. I strongly, as an attorney representing clients, I'm a big believer in settling. I'm a big believer in communication, trying to talk, trying to work things out. But oftentimes, you know, there's some issues certainly that that arise and can make that extremely difficult. So, you know, it's really important for individuals to know that the association, once there is a matter involving an alleged violation of a rule or covenant, the problem there is that the law and the declaration is really, you know, there's a lot of information in there, and things can get really out of hand. And so the homeowner really needs to take some quick action and try to get information, try to get legal advice so that they can understand how best to handle it. Because a lot of people don't understand, a lot of people don't know that homeowners associations can foreclose. So that's important to know. Here's some HUD-approved housing counseling agencies. Oh, that's just part of the slide. So I'm going to stop my my sharing.
Thank you, Mr. Vasquez.
Yes, sure thing. Okay, here we go. All right. Well, thank you very much.
No problem. And appreciate it's a lot of information as folks are seeing. These can be really complex. And I think, you know, one of the things that folks have been surprised about is the HOA's ability to place a lien and actually, you know, initiate foreclosure on an HOA. And I think that's something that a lot of folks don't understand until it gets there, right? And that could be the only lien left and they're able to initiate foreclosure. And I think, you know, it's really important for folks to understand that. And like we keep saying, right? I mean, we're here for resources. We're here to help guide questions and be able to guide you. But in terms of legal advice, you know, there's different organizations that are available, and, you know, Colorado Legal Services being one of them. And that's that. So we do have a few questions, and, you know, I do want to make sure that we're on time here. So one of the questions in the chat that I saw was specifically for someone that has struggled to pay HOA fees because of COVID-related job loss. Do they have any kind of special protections right now? And I do want to recognize, you know, our partners in DHA and OFEP and folks who are here, and also my Director of Recordings and Chief Deputy Public Trustee Emeritus John Davis John Davies. I'm sorry. See, John, I owe you a beer now. Is on as well too to help with some of these questions, as well as Charlotte O'Donnell and Betsy Cohn. So welcome. And so first question. That's the first question. If somebody had struggled to pay HOA fees because of a COVID-related job loss, are there any special protections for them right now?
So I am not aware of any law that's been passed by the Colorado State General Assembly with regard to HOA specifically. Unfortunately, HOAs fall in that kind of strange category of, you know, private right to contract, unlike renters or even some assistance that might be available to mortgagees. What I would suggest a homeowner who's having difficulty keeping up on their HOA dues because of a COVID-related issue, do the best you can to be as candid as possible with your board. They are human beings. They're your neighbors. And I get calls every day from boards who are asking what more they can do to try and help people. So that is, something that you can do. But unfortunately, again, because of that private right to contract and the nature of HOAs generally, I'm not aware of any specific programs that are geared toward HOAs.
Thank you.
Yeah. I've gotten that question from several of my clients, and unfortunately, I have to tell them that doesn't that does not. There are no special protections for homeowners in this situation. It's completely up to the discretion of the association. So if the association doesn't want to do it, that's tough. And the problem here too is that, unlike mortgages, who, if you have a mortgage loan, there's program after program, there's foreclosure moratoriums, there's loss mitigation. There's absolutely nothing like that with the Homeowners Association. So I've often counseled my clients that if you cannot make both your mortgage payments and your HOA payments, you make the HOA payments, because there's probably a greater likelihood that you're going to get some type of loss mitigation to the crisis that you're in with the mortgage company. Not to say that can't happen with the association, but again, it is solely up to the discretion of the association.
If I may say, of course, both of them are correct. There are no protections. However, there are statewide resources that can assist with curing the HOA. There's a program called MAP. There's a program called, that's Mortgage Assistance Program.
Yep.
There's Bank on Denver. So, and the other value is you could reach out to one of the HUD-approved counseling agencies, because we can counsel you, look at your hardship, look at what's being requested, help assess if it's reasonable what the HOAs are asking, if you have not sought out legal advice, such as Jose. But there are times when sometimes we can appeal to the HOA. Listen, this person has taken the time to get housing counseling. They're really sorting out their budget. They're trying to get back on track. And, we might be able to negotiate something that's a little more reasonable with the HOA. But there aren't protections, but there are some financial resources if they qualify to bring the HOA current.
Are these resources also available for elder or older adults who are faced with HOA-related foreclosure in their communities? I mean, a lot of folks are on fixed incomes. A lot of folks, are still struggling. Is there anything specific for our folks in our aging community, elders?
Any of the programs that I just happened to mention are available to anyone that has a HOA hardship and possibly a mortgage hardship. We then would have to look at their circumstances and see if we can get them qualified. Bringing their HOA current is very helpful, but if it's not going to long-term resolve the matter, the person's going to continue falling delinquent because they don't have enough income. We have to reassess what can be done. But these programs are available irrelevant of their age or income. So.
Am I, this is me putting my former hat on, usually multi-unit apartments, gated communities, private developments, things like that. Condos typically have HOAs, right? And what would you advise folks? I mean, if they do own a condo or are part of a covenant in situations like that. I mean, a lot of folks may not know that they're in an HOA, believe it or not.
Yeah, unfortunately, the best time to determine that really is before you purchase that home. It's kind of like signing a contract without knowing what the terms are. So we here at the HOA Information Office, our mission really is to get to people before they purchase that home. Once you're there, of course, educate yourself, get all of those governing documents, read through them, ask questions of your board. And again, I can't stress this enough. If you do discover you're part of an HOA, find out how to involve yourself in the governance of that HOA. By being involved in the process, you're always going to be ahead of the game.
I mean, you know, the problem is that, you know, even individuals who are aware that there's an association, you're talking about covenants that could be, I mean, over 100 pages. And the rules may be just as long. So oftentimes it's really hard, I think, to convey that information to homeowners about what's in those documents. And I would encourage people to go to the HOA resource board, because you folks know exactly what those obligations are and what that obligation entails, and what the statutes say about the potential for being on the hook financially for any violations. So, I mean, I would encourage people to reach out to the association board, to reach out to the associations themselves, and find out, you know, what are my obligations? Because I think oftentimes people, they might say, oh yeah, it's part of the association, but in essence, the homeowner is giving up significant control of their ability to make decisions with their property. And, you know, a lot of people have a very hard time with that concept. But if you start telling people, listen, you could get into serious trouble if you don't do this. This isn't just like, well, you can just disagree, but you could, in the worst case scenario, lose your house. So, I mean, it's really important that people need to find out, to get that information about what's involved.
Well, I'm going to pause real quick. I know we're at 7:01 and the storm has passed, and it looks like the sun is out. So I want to make sure that people have the gift of time this evening. Are there any other questions? Anything else for folks on the Facebook live chat or on our Zoom webinar? Are there any other questions or any other final points before we adjourn?
I'll just say, if you're contemplating becoming a new homeowner and you think it might be in an HOA, please feel free to reach out to me and ask questions. Knowledge is power.
That's 100% correct. And for those of you who missed the first part of this, know that it's recorded. You can go back and watch the whole thing. Riveting, and the box set will be coming out probably next season, but I'm just kidding. Our wonderful Zoom pandemic box set. No, these are all available for you for your information. There are different topics regarding foreclosure, financial help, things like that. But we appreciate it. Thanks, everybody. And until next time.
Stay well, everyone.
Thank you. Take care.